Good evening, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. And for those of you that saw my video earlier, the UCC decoded, there were some things in there that I got sidetracked with my buddy Andy that hopped on with me, but I wanted to do a rundown real quick on some basics starting out in this and trying to figure out what's going on in your life in regards to these court procedures. And what I want to explain to everybody is that today everything in the courts is under equity, and that's why they fly that Admiralty Maritime flag in the courts. Your equity laws start with your trust laws, your international trust laws. And then you have your maritime law, which is your international code. And basically what we're talking about in international laws, it's just like we say when we talk about the Constitution here in America, the state laws have to run in accordance with the Constitution. Well, the United States Code has to run in accordance with the Uniform Commercial Code, which is international law. And then if you've been doing any research on this, you've probably already researched the subject that your state statutes are under international law. They've been reconveyed through Congress to sit under international law through the UN. And what that means is they also abide by the Uniform Commercial Code. And the way it works is that the states have their statutes written, and then within those statutes is the Uniform Commercial Code in accordance to their own corporate operations. And then, like I said, you have the United States Code, which incorporates the Uniform Commercial Code in their corporate operations. And so when we look at today's laws, everything is under equity, and so your remedy lies in equity. In other words, everything that's presented to you is a contract. Even when you accept a Federal Reserve note, which is a compelled benefit, it is done under an adhesion contract note. It's an actual promissory note, which is a negotiable instrument. And when we see that negotiable instrument here in America, the Federal Reserve note, as a compelled benefit, has an exemption. And that exemption is written in to the Uniform Commercial Code. And what I want to discuss is the pathway to that. Yep, there it is. And so basically when we talk about the Uniform Commercial Code, it lies within the U.S. Code, United States Code, and your state statutes. Every state statute, or every state has a set of statutes, and each state imports the Uniform Commercial Code within their statutes according to the way each state wants to do that. But it has to incorporate them in there. And basically, when we talk about this pathway to remedy, we start out with what they call reservation of rights, which is the Uniform Commercial Code 1-308. I prefer to call it retention of rights, because the rights that I have already exist, and therefore it's not a matter of reserving them like you make a dinner reservation at a restaurant. What you're doing is making a reservation for a future event. I'm not reserving anything. I already have them. They're inherent and unalienable within myself, and therefore they are retained. So, and it's just a matter of wording. You can use reserved if you wish. It doesn't really make any difference. It's just my preference to use retention. So anyway, we have UCC 1-308, which is a retention of rights, reservation of rights. And when we use that, what we want to do is we want to make a note of that foremost, before any kind of signature, autograph, or mark. And what that does is it implies a present intent prior to the admission or authorization. So your intent is very important in this stuff. So your intent is to retain all rights by denoting the 1-308 first, and then putting your autograph, mark, or signature. Then when we see the old version of the retention of rights was 1-207, in that they clarified that the codes were construed to be in harmony with that of the common law. Now they've taken that wording out and they've changed it around, and it now resides under UCC 1-103, but the wording is nowhere near that, and you have to really read into it. But the 1-103 is the hierarchy of law. It's going to have it gives you access to your ecclesiastical law, your canon laws, your contract law, your U.S. codes, your state statutes, your bankruptcy law, whichever law that applies to your particular situation, and it's your choice of law. And when we talk about a choice of law, there are different, like I try to explain to people, there are different remedies. And so it just has to be according to your own situation, and you have to be the creator. You have to create your own remedy, because the remedy isn't there within the code itself. It lies within yourself according to your own situation. So again, you have to pick your choice of law, and in order to do that, you have to be learned of that. And there's I'll have to look it up again, but it comes to reference to employment of professionals in regards to your situation, and it's part of the United States Code. I'll look it up again sometime. But you have the right to assistance of counsel. You don't have the right to an attorney or the right to a lawyer. You have the right to assistance of counsel. And that counsel can be accountants, it can be medical doctors, it can be lawyers, it can be teachers, it can be professors, it can be a friend, it can be anybody that can give you that you can apply it and be able to appropriately respond to the opponent, whether they be a plaintiff or a defendant in your case. That's a very important thing. First, you're going to retain your rights with 1-308, and then you're going to show them that you have a choice of law under 1-103. And you'll see this stuff in one of my previous posts, a couple of them actually. There's like 6 or 7 of them that I've got in there. I think I just included another one as far as collections, and we'll go over that here through this. But so now you've got your retention of rights, and you're letting them know that you know of your choice. And then under 1-105, it's listed as severability. Severability is your ability to sever ties. That's severability. And basically what you're going to do there is you're going to point out that you're foreign to that corporation. Because in any court of equity, the plaintiff has to prove on and for the record that the defendant that they have particularly encountered be identified as a U.S. citizen. They have to provide sufficient proof that that citizen is a corporate artificial person so that they can sue them in their corporate artificial capacity. They can't, a corporate artificial entity cannot bring suit against anything else but another corporate artificial entity. A living man can't bring a suit against a corporate artificial person in his private capacity. He can only do that in his personal capacity, acting as the citizen, or acting on behalf of the citizen. Period. That's the only way these courts work. So once we've established the retention of rights, the choice of law, and that we're foreign, we're going to give them notice. Under UCC 1-202 is notice and knowledge. So, okay, well, let me take this cover off and see if that helps. Hopefully that'll help the sound. So anyway, now we've got retention of rights, your choice of law, your severability, which is your foreign state status, denoting that you're not the corporate fictional person that they are charging in the financial instrument presented before the court. And then your notice, giving them notice of this. And then you have, and that's a simple one. You're just going to give them notice, pure and simple. And as I spoke about in the UCC decoded video earlier, one of the first things that you want to do in any court case is enter ability so that they can't bring the suit any further. Because if the judge is standing up to his canon duties under his judicial capacity of government, not his judicial capacity of corporate administration, but there we are again. So anyway, under UCC 3-502, we talk about dishonor. And what they've done when they bring these cases is, like I said, they've brought them against the living man instead of the corporate artificial person. Or they've actually brought it against the corporate artificial person, but they're putting these warrants, these administrative warrants, called bench. Right now, he doctored one up with all kinds of colors on it and sent it back to him. Hugs and kisses and everything. That was pretty cool. But basically what we're doing here is we're accepting these warrants as valid, and they're not. They're bench warrants. They're administrative warrants. They have absolutely no enforcement except for the fact of the cognitive dissonance and the indoctrination of the enforcement officers who are being trained to do this. And the UCC 9-402 under securities. And it's all securities frauds. Each one of your states has what's called and that maturity date is the term of a court. The term of a court is 1 year. And so at the end of that 1 year, those securities funds are going to come back, and there's going to have income on them, and it's going to be derived in your name. And what's going to happen is the court's not going to tell you that there was income derived in your name off of that case. And so the system, you can go ahead and pay the taxes on that and assign the IRS to do a what's called a forensic accounting, so that all accounts are balanced to zero, and the proceeds, the income that was derived from that, take the taxes out and disperse the proceeds to its rightful owner, which would be yourself, or the beneficiary, which would be the estate. Either way. But anyway, that's what's happening in these courts, and that's why I think it's so important to denote these UCC codes, because everything is in equity nowadays, and the only way that you have remedy to take it to common law is to use the process, the administrative process that they provide under these equitable laws. And once that process is exhausted administratively, now you can take it to the judicial end of things through the common law and present your case, which is already adjudicated. If done properly through process, you serve them the first time. If they ignore it, that's 21 days, they've acquiesced. You give them a second notice, with another 10 days, they don't rebut it, that's acquiesced. You give them another notice with another 3 days. If they don't rebut it, that's acquiesced again. 3 times unrebutted remains as truth in law. So now you have your valid claim. It's a law that you take to the judicial end of things through the Supreme Court, present the evidence. It's already there that they've not rebutted it, so they've admitted tacitly to guilt. And therefore the adjudication is already guilty. So now you just have to provide your remedy. You state your claim, you show the evidence that they're guilty, and then you state your remedy. And that's how that's supposed to work. So the common law still exists, but it exists only in process. It does not exist in the substantive part of it where you use that in process before your equity. It's not going to work that way. You have to use the equitable remedy or equitable process first. If you get no remedy there, then that shows your guilt on the common law side, which is your access to the common law. So That's why they say it's important to stay out of these courts and do everything by paperwork. If you can do everything by paperwork and get it down so that eventually one day you can go into court and iterate this stuff by word, then so be it. All the more for you. 2 affidavits and certificate of commercial dishonor if not rebutted. You don't need a certificate of commercial dishonor either. You just need proof that they've acquiesced and not rebutted your statements of facts. And as long as your statements of facts are true and they can't rebut them, then they'll stand and they can't rebut them. So just make sure that your statements are as true as possible. And anytime that they do rebut something, it just means they've found an error in it and you need to correct that. But that's all it is. It doesn't mean that you're going to be found guilty. It just means you've got a correction to make. Because no matter how you look at it, they're the ones guilty, not you. So again, people, understand this stuff about the UCC and go back through my posts and find the ones that I showed this stuff. What is it? I reserved the right to lien my person. And it shows all these codes. UCC 1-308, retention of rights. UCC 1-103 is the hierarchy where it gives you your choice of law. UCC 1-105 is the severability, where you show that you're foreign to the corporate fictional entity that's bringing the claim. And then you've got UCC 1-202, which is notice and knowledge. You've noticed them. They now have knowledge. They can't rebut that. Then you've got the UCC 3-502, which is your dishonor, where you point out that their actions are being done in fraud because they have no parity, because they're bringing a living man in instead of the corporate artificial person. Then you have UCC 9-402, which is your secured party not obligated under the contract. And then UCC 9-607, where it gives you, as the secured party, a right to collect. Ohio says UCC is incorporated, but not 9-102 and 9-109 doesn't apply. It most certainly does apply. It's international law. And like I said, what they're doing is they're violating international securities laws in these court actions. Because again, like I said, they take all these bonds, they pool them together, and then they securitize it. Now, whether anybody likes to believe it's fraud or not, my opinion is it is most definitely fraud, because what they've done is they've hypothecated a customer's securities. Understand that. They've hypothecated a customer's security, and they are not acknowledging that or giving notice to that supposed customer that they have income being provided through that security so that they can claim it when it matures. That's another part of the fraud. If it's not done in fraud, then they would be noticing people that you're involved in a commercial activity that is generating revenue, taxable revenue, which only applies to corporate entities. And therefore, that's why I say when you try to collect proceeds from these, I don't think you'll collect them yourself. I think they'll be collected towards the estate. Because the revenue can only be generated by a corporate artificial person. A living man doesn't generate revenue. A living man operates the corporate artificial person that generates revenue. Remember, is merely a transmitting utility for conducting commerce. Otherwise, the living man trades and barters. He uses his voice to trade and barter. When he writes things down, then he's acting in a corporate artificial person, constructing a contract. And that's why it's so important to have signatures. And remember, people, no contract is actually a contract unless there's just make sure you cover your ass with that 1-308. Anything can be fixed from there, but if you don't do that, they're going to hammer you. They're going to hammer you hard until you learn this. But the beginning of any learning of this is to use that 1-308 or similar language. There are many different ways to do it. You can do it simply with a dot, dot, dot. That's correct parse syntax grammar. And the dot, dot, dot just simply means not including all that needs to be said. Now, whether you put that at the beginning of a statement saying that there's more to be included before what you have to say, or if you put it at the end of a statement saying that there's more to say after what you've had to say, it's still a reservation of rights. It's just a different way of saying it. You can do all rights retained without recourse, or all rights reserved, none waived. Anything that shows an intent to retain your rights, period. So anyway, and yes, UCC 1-308, all rights reserved. The estate is asset funds and only good for discharging existing debts. Correct. The citizen of the United States is part of the Public Charitable Trust of USA Incorporated. And basically what it is it doesn't have any actual assets in there. It is just a funds. Matter of fact, the IMF, if you look up under the IMF or IRS, IRC, Internal Revenue Code, I believe they define funds. And funds is the funds provided from the IMF. So in regards to the IRS here in America, it's the funds derived from the IMF and then exchanged through the Federal Reserve as in regards to Federal Reserve notes. In other countries where they use different currencies, it would be the IMF funds through whatever corporation that they're running their currency through. So it's still a fund from the IMF in each and every one of these countries. It's all the same fund, and which is a fictional fund based on currency that has no intrinsic value. So the estate is just asset funds for discharging existing debts. And that's here in America, that's called your exemption, period, because the bankruptcy that they're currently in and have been in for hundreds of years. How do I discharge the arrears or arrears? Depends on what you're talking about, and actually it doesn't really matter, I guess. It doesn't matter what you're talking about, because everything is based on Federal Reserve notes, which is a compelled benefit, and an adhesion contract. And I'll explain that by using the HJR 192 and Public Law 7310 about your exemption. What you're going to do is you're going to assign the correct fiduciary to do the accounting, to balance all accounts to zero. And that fiduciary, take notes people, that fiduciary, in regards to the birth certificate, the certificated citizen of the United States is, there we go. So anyway, the fiduciary assignment in regards to that would be Mike Pompeo, Pompeo, and he is the Secretary of the United States Department of State, and he is the foreign consular when it comes to international affairs. And what it is he's going to be taking care of. He's the head of the Comptroller General, Comptroller of Currency through the U.S. Treasury. And what he's going to do is he's going to assign, per your order, a forensic accounting to balance all accounts to zero and send any proceeds or income derived from and is part of the Public Charitable Trust of USA Inc. And therefore an obligation of the United States, a vessel of the United States, and it is located in the District of Columbia. Bob Roper says, send a fiduciary appointment that they use the asset account to discharge child support debt on and or agree it's been paid. There you go, Vernon. And that's, I would actually suggest that. Go ahead and that bond he's talking about. I'm hoping you're talking about it, Bob. Is the birth certificate. Send him that birth certificate. Send him a copy of that saying, hey, here's my exemption. Here's the person that's... Okay. So anyway, I hope that's what you're talking about, Bob. That's what I would suggest. It's the only one that can get a copy of that is yourself. And that itself is self-authenticating. You walk into court with a birth certificate, the Secretary of State's not going to send it to Joe Blow down the street. He can only send it to you. And when you walk into court and you're the one that they're addressing with the same name, then that pretty much self-authenticates it right there in a physical sense. You don't have to authenticate it through the state or the federal department. So, and I'm working on that one myself. I entered mine into my case a couple years back and didn't get the right results I was expecting, but there you go. Yes, you see that, Vernon? It says, paid to the U.S. Treasury and charged to Bob Roper. Now, I don't know what you think about this, Bob, but I believe they've already charged Bob Roper, and they now have to offset the book, so they now need to credit Bob Roper. I think that's a large part of the problem. I think people are doing it wrong when you say paid to the U.S. Treasury and charged to Bob Roper. They've already charged to Bob Roper and they've already paid to the Treasury. You just have to iterate that. And you iterate that by now telling them to credit Bob Roper. They've already charged him. They've already got that on the ledger. That's why it appears there. So now you need to balance that by crediting Bob Roper. So anyway, that's the bond order. Charged to yourself, not me. Right, but what you're going to do when you use your exemption, they've already charged the Bob Roper, the all caps Bob Roper. Now they're trying to charge the living man. And what you got to do is you got to tell them you're the creditor. So when you tell them, pay to the U.S. Treasury as already charged to Bob Roper, now credit Bob Roper. You understand that? It's just like the header in the when you file a claim. You're not going to be filing your claim as Bob Roper, the all caps. You're going to be filing your claim as Bob Roper in the correct parse syntax grammar as representative for Bob Roper, the all caps. Right. It without crediting it. Exactly. See, you've got to think of all accounting. There's two sides. You've got the positive and negative, and you got to be able to balance them out. So when you charge one side, you got to credit the other. Exactly.